if some of you are not able to attend for all 3 days, then it's possible for you to just do the post-conference survey whenever it is that you have last attended. For feedback reasons, technical feedback reasons, I'm going to ask everyone to remain muted unless you are speaking or you wish to join in the Q&A. That really helps with background noise and feedback loops and things like that. And it's so wonderful to see so many people in the chat saying where they're from. What a diverse group we've got here. So that should really help us have a good set of knowledge going forward. So the last thing I would like to say is to thank the conference team. So our conference team consists of, obviously, Balbir Gurm, Tally Wade, Monica Verma from the Dixon Transition Society, Kay Dennison from Delta Seniors Planning, Kamalji Warach from PICS, and Gloria Salgado who is both a gerontologist, works in researching gerontology. So my screen keeps changing, but I'm now going to just say that we're moving to our first presentation, which is Cheryl Gabriel and Lee Caton, Cheryl is the hereditary chief of Kwantlen First Nation, on whose lands we are hosting this virtual conference, and Lee Caton is the elder in residence at Kwantlen Polytechnic University. So over to Balbir to set that technology in action. Yes, I'm just texting, I'm no sound.
Balbir, there is no sound in the video.
If you click the 3 dots where you've gone to share your screen, it'll say share audio, and then maybe that will help.
Yeah, just check it, Mark.
Okay. We're going to play that again.
Still no sound.
There we go. Still not working?
Just pause the video. Are you muted?
Yeah.
So folks, this is one of the technical difficulties that we're hopefully not going to have too many more of, but if you can just bear with us.
It worked when we tested it. It's always the same, right? Okay.
It's always the same.
Okay, let's see if it works this time around. No?
So click on stop share and try to share the screen again and check mark share audio again.
Okay. Stop share. Okay, we're going to try this one more time.
Click on share screen button and check mark share sound.
Share sound after share screen?
Yes.
Okay.
Then click on share.
Okay. Share sound. Screen 2. Share. And back it up.
Thank you. Hello, everyone. I'm Squayatin, Cheryl Gabriel, Caton's wife and partner. And we are doing this on behalf of Kwantlen Polytechnic and the conference that's going to happen after our welcoming. And I want to thank you all for inviting Caton. And I get to be part of his work life for a few minutes, and I enjoy watching and listening to my husband. And I hope you all have a great day with this conference that you're going to be part of. Alma Relations.
Thank you, my dear ones that are put together the conference for this, the most important part of each and one of your lives, and also the history of all of you who have witnessed and grew up with the history of racism and violence towards all human beings. It's always been a known factor that there was always the bullies amongst us when we were growing up, but at the same time, there was also the predators. There was also those who abused our people in the institutions, and it goes on when they came out, and it followed everybody for many, many generations. And here we are today where we're still trying to find ways to eliminate those certain things in our relationships when it comes to a man and a wife, or a partner and a wife, and things like that. It's so important to try really hard to not only forgive, but to understand that word of forgiveness, that law of forgiveness that we so much forget about. And if we don't do that, then our children and grandchildren are going to suffer dearly. We must always put them first. We must always put them on the front burner, not on the back burners in our lives, and laws and ministry acts. The ministry needs to be stronger. Our leaderships in our nations, they're strong, but it doesn't matter. They still need to be stronger. And by being stronger, you're looking at communication amongst not only committees, but the members of those committees that live on and off First Nations, but also amongst the urban societies that surround the First Nations people. And when you look at that scale, you're looking at the scale of North America and the world, and why these things happen. It's totally disgusting how the women and children are dying off in this age in 2021, and how they suffer so dearly, and it's not right. We know it's not right. They know it's not right. But the children, and the children give back unconditional love to the parents and to the teachers and stuff like that, and they have to still grow in our society. And when we are with our grandchildren, and I have 13 now, and Shoyatan and I have 13, they are so beautiful. They're my life. They're my next breath. They're my heartbeat. They're my good thoughts, and they're my painkillers that have been taking away my pain, because of the past stuff. I really look forward to seeing their little happy faces every day, because it's a remedy that you cannot find in a drugstore or a doctor's office. That is unconditional love from the grandchildren. And I do thank all the mothers and grandmothers who have raised all of their children in certain ways, and always look at the importance of the heartbeat, the importance of the earth and the sky and the universe, and what's on earth and what's in the earth, and to all the sacred things that we share, such as the food source. We share knowledge. We have many in our long houses that was considered our house of knowledge. And when the people left there, they were the knowledge keepers. And that meant all of our languages and life sources and everything like that we seem to sometimes set aside because we get too mixed up in the world, and we don't know what to do about it. But now I know in our institutions like KPU and other universities, they're going to do their best to eliminate that in our campuses and around the schools and around the daycares and around everywhere that there's a human being that suffered that a while back. We know the importance and we know how to deal with it now. We have great teachers and we have a lot of students coming out with their doctrines and their sources of graduating universities to help mankind. And so I congratulate everyone that does that for us, and they're all my frontline workers, and we love them so much.
Thank you.
So I'd like to do again, maybe this time I'm going to sing Kwantlen song, even though this song is it is of great importance to all of the territories, because it recognizes that you all belong to a territory, and it recognizes the land base in which we still have today, that we look at, that's our territory and that's our sacred land. So all these songs that come off that sacred land and water are important to all the generations still behind us. Thanking you when you hear me say, I'm thanking all of you, and that's going to end my journey with you today. And I thank you. I say Heitzka to everyone that put this together for us. Kwantlen. Oh, 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 And also, yes, while you were on a little pause here, Samantha, I'm going to pause it for about 10 more seconds, and then I'm going to do a closing song for your conference. And you can do this one at the end.
Thank you, Cheryl and Lucaton, for that welcome. And Lucaton spoke of children, and I think we should take a moment to reflect on the fact that we have recently learned of an ongoing trauma I think some of us suspected that it was there already, but on behalf of NEVR, I would like to acknowledge the ongoing trauma affecting our Indigenous communities and families due to the recent findings of the mass grave at Camlock's residential school. This is an example of systemic violence and a reminder to us all that trauma does not remain in the past. It is ongoing. I would now like to invite Dr. Balbir Gurm to inform us, what does NEVR do?
Oh. Jen, I think we're going to invite Dr. Davis to do a welcome.
Oh, I think you are correct. Sorry, I'm moving down. Yes, so the president of Kwantlen Polytechnic University, Dr. Alan Davis, is also providing a welcome.
See if I do this better this time.
Hello, my name is Alan Davis. I am the President and Vice Chancellor at Kwantlen Polytechnic University. KPU serves a region that overlaps with the traditional and ancestral territories of the Hunkaminam and Senchothan speaking peoples, which includes the Kwantlen First Nation, who graciously bestowed their name upon this university. We thank the Indigenous peoples of this region and beyond for sharing their land and resources with us in friendship and in peace. Welcome to this, the latest event hosted by the Network for the Elimination of Violence in Relationships. And a big shout out to our colleague, Dr. Balbir Gurm, one of KPU's finest. We thank her for her dedication and commitment and for her ability to bring together diverse sectors to focus on all aspects of how to keep our families and our communities safe. And a big shout out to all of you for taking the time over the next 3 days to explore an integrated court system by trying to understand court processes and make recommendations for changes that improve the experience for survivors. Well, enough from me. You have some outstanding keynote presenters to come up, and I'm sure lots of opportunity for rich engagement. Again, welcome, and I wish you well in your endeavors.
Thank you, Dr. Davies. Our next two greetings to come up is the Honourable David Eby QC, who's of course our Attorney General and the Minister responsible for housing, followed by the Honourable Katrina Chen, Minister of State for Childcare. These again are videos.
Hello, it's David Eby, BC's Attorney General, and I'm coming to you from the traditional territory of the Lekwungen-speaking people, the Songhees and Esquimalt First Nations. Thank you very much for inviting me to the Network to Eliminate Violence in Relationships conference. I want to begin by really saying how much I appreciate and am grateful for the work of all of the folks who are at this conference and all of the people across the province working to eliminate violence in relationships. We know the kind of harms and trauma that violence in relationships causes in our province and communities all over BC, and I'm very grateful that you're coming together in this really positive way to respond to and address this violence and work towards its elimination. Many of you will know the province has more than 400 victim service and violence against women programs in BC, and every ministry in our government has responsibility to address this issue and issues of equality and equity in our province, and the Ministry of Attorney General is certainly among those. That's why we've taken steps in the Ministry of Attorney General to improve the supports in the justice system for families, including families facing violence. On May 17th, new provincial court family rules came into force. These new rules are really about trying to minimize some of the conflict that can really ramp up tensions in families by working at a very early stage to try to address family concerns and keep them out of court if possible so that families can reach their own solutions. Now, obviously not appropriate for all families, especially if violence is an issue, but really trying to avoid some of the conflict that the court system can bring for families that don't have that history. And we're seeing really positive results. with Surrey and Victoria as early adopters of this model. We also recently proposed amendments to the Family Law Act in the legislature to better support those experiencing relationship violence. There was an understanding in the courts that intent was required to satisfy the definition of family violence and to consider violence that impacted families to be family violence. And the legislation that we proposed in the legislature makes it clear that the intent to harm is not necessary for violence to be considered family violence and to be considered by a court in the Family Law Act. This is going to better protect at-risk family members and really reduce barriers for those applying for protection orders, as well as guardianship, parenting arrangements, or contact with a child to access justice. The BC Prosecution Service, of course, provides regular training and support to its members and Crown Counsel and has a dedicated policy to respond to intimate partner violence, including prioritizing these cases in our court system and assigning trial counsel as early as possible to support victims, and especially where there's a significant risk of serious harm. The province is also currently seeking input from stakeholders and the public on legislation to prevent the sharing of intimate images without consent. MLA Grace Lohr is leading this really important engagement work across the province, which will result in legislation that assists victims in both getting easy and convenient takedown orders from the court to remove photos, but also compensation for what they're put through. Obviously, this can be a form of intimate partner violence or used to extort victims for additional images, sex, or money. A comprehensive approach to this in BC is going to make a real difference for victims and help people get results faster and better access to justice. Obviously, talking about access to justice, legal aid is really important. We have invested significantly more in legal aid since forming government, including establishing legal aid clinics across the province. Families in need of legal advice also have access to a free lawyer and advocate through the parent legal centers in 10 communities now in the province. You know, we know that there's lots more work to do, but I think we're on the right path, and we'll continue on that path with the advice of all the participants in this conference about how we can work together to eliminate violence in our province and respond to relationship violence when it happens. Thank you very much for your work. Thank you for your tireless efforts to support those facing violence and helping them overcome their trauma and get their lives back on track. Have a great conference.
And up next, as I said, the Honourable Katrina Chen, Minister of State for Childcare, and Balbir is just working on bringing up that video.
Hi, this is Katrina Chen, MLA for Burnaby-Lougheed, BC's Minister of State for Childcare. I want to thank all the organizers and volunteers of the Network to Eliminate Violence in Relationships for your important work to organize this conference and to have the much needed conversations and to find solutions together to end violence in all forms in our communities across BC. As a survivor of gender-based violence, I personally know how the trauma and experience can impact survivors, victims, and our loved ones for a very long time. We need better process to ensure victims and survivors don't get re-traumatized through the justice system. And we need real justice and also solutions to prevent violence from happening to more women and individuals in our communities. I look forward to learning from you all from this very meaningful conference, and that's all take a moment as we do this work to think about all the women and individuals who may still be struggling in unsafe situations right at this moment. That's all take actions together now. Thank you so much.
Thank you to them. Moving onwards, we have a greetings from Mayor Doug McCallum of the City of Surrey, followed by Mayor George Harvey, the City of Delta. And whilst we wait for Balbir to be able to get those on to them, we are working, some of you are asking about the survey link, if you could be put in the chat. We are currently working on that. It will appear.
Hello and welcome to the 2021 NEVR Conference. Violence in relationships is a shadow pandemic that affects us all. And unlike COVID-19, there is no vaccination to cure this problem in our communities. That is why this conference is so valuable, because it is a forum to generate ideas, share initiatives, and create new partnerships. This year's conference focuses on the court system, its effect on relationship violence, and how the current court model can be improved. I look forward to reviewing the recommendations on how to advance the court system that will be produced from this conference. And as you share ideas and engage in dialogue over the next 3 days, know that your participation and support of the NEVR Conference is making a difference. I want to commend each of you for the important work that you do and for your continual contributions to help eliminate the relationship violence in our communities. Hello and welcome to the
I'm George Harvey, Mayor of Delta, and I'm honored to welcome you to the 2021 Network to Eliminate Violence in Relationships, the NEVR Conference. I'd first like to extend my sincere appreciation to founding member and facilitator for the Network to Eliminate Violence in Relationships, Dr. Balbira Gurm. Dr. Gurm continues to work with frontline service providers and community partners to create resources and facilitate workshops towards a society free of violence. Dr. Gurm, thank you for your outstanding dedication and tireless advocacy work for systemic change. Your work is truly appreciated and helps us build safer communities. This year's conference focuses on healthy relationships and justice, two critical foundations towards creating awareness of domestic violence and preventing abuse through education. Your input and collaboration on our current court system is important as we work to improve these systems to ensure support is provided to victims in a timely manner. By working together, we can help mitigate long-term effects and issues with our current domestic violence court system. Our actions matter, and my heartfelt thanks to each of you for your participation in this important conference. To the service partners, educators, police, justice, and partners in government, thank you all for your ongoing work and contributions towards eliminating violence in relationships in our communities. You know, abuse should not be tolerated, and there remains much work to do in eradicating violence and abuse in relationships. Together, in solidarity, we can show our commitment to ending violence and supporting survivors. Your voice and your influence is important and key to helping build a more peaceful society. I would just like to also say that it's all about now getting the shot. We must work together. We must get immunized to end this pandemic. With your support and others, we can get through this, but please get your shot and please tell others to do the same. Thank you very much for your time. I'm George Harvey, Mayor of Delta, and I'm honored.
So thank you to everyone who sent their greetings. I will now re-invite Dr. Gurm to talk to us quite briefly about what NEVR does. Albir, over to you.
Okay, thank you, Jen. Can you hear me?
We can hear you.
Okay, just want to make sure with all the technical difficulties I've been having this morning. And thank you very much, Jen, for being the MC for today. But before I start, I want to acknowledge that I'm a settler on the land of the Coast Salish people, the Kwantlen, the Katzie, and the Semiahmoo nations, and I really want to thank them for their stewardship of the land. So what I'll discuss is what is NEVR, sort of our little history, the scope and vision, some of the things that we've managed to do, and the purpose of the conference, which I may not spend too much time on because a lot of our politicians did that. So in terms of NEVR, we started because people work in silos. We got a lot of feedback from service providers, government, different agencies that everyone's working in silos. We're not sure what each other does, even within our organization, never mind across organizations. And there was a lot of energy and resources being wasted in duplication. As well, there was some disconnect between what was in theory and what was in practice. As well, agencies identified that they always didn't know the best way to evaluate programs. In addition, service providers felt that they could not advocate for change because they were funded by government. So I was asked to create that space. I agreed, but I wanted to understand the system better. So our very first participatory action research project was done with a group of us. We had investigators were Miriam Majetti from Surrey Women's Center, Pardeep Sahota from PICS, Gary Fandy from the Justice Institute, Nadia Gill from SFU, Jay Tuason from KPU, Andrea Ingalls from MCFD, and then we had collaborators were the Surrey RCMP, Yvonne Dandrand from Criminology at UFV. As well, we had Diversity, Vancouver Lower Mainland Multicultural Family Services or Support Services Society, and Surrey Courts. As well, shortly after we started that, we had the DPD. At that point, we had Chief Jim Sesford, Kay Dennison from Seniors Planning, and then Battered Women's joined shortly after, and then it just kept growing. So what we basically did is create a space to bring everyone together, to figure out how do we best address relationship violence? And that's how our committee was formed. So one of the first things was, of course, to name it, and that happened, but also the scope was to look at relationship violence totally. We wanted to address all aspects, the physical, the sexual, the emotional, the spiritual, and the financial, and all age groups, and in any space. So whether it was at work or at home, so it was broader than domestic violence. Our vision, of course, was that we would dialogue, bring our perspectives together to form a community of practice so that all organizations can bring up any issue, share what they are doing, and ask for support. And we would all work with each other. And so our vision, of course, is to eliminate violence in relationships. You heard that enough. But what is important is to figure out what is it that each organization wants to do and how do they want to work with each other. As some of the academics on the team, we can help with literature, develop and implement projects, figure out how to evaluate, and we do all that through students. So our membership, I gave you a little history of how we started, but now we have over 200 plus members, over 100 organizations, and we are cross-sectoral and we're open to anyone. So everyone can join, and you've got the never@kpu.ca email. So if you're interested and you're not already a member, you can join. It doesn't mean you have to do everything all the time. So our members come and go. It's very fluid. But when you're there, you have equal membership to anyone else to make decisions. Some of the things that we have been able to do or what we do, I'll talk about a few of our accomplishments. So of course, the yearly conference we've been doing, and I think this is our 11th one. One year we actually did a play, and that's what you see on the right side of the screen there. And that was our conference. And then it was followed with a fundraiser with the same play. We've developed many toolkits, but one of the more used ones is the community champion one. So it's for bystanders, how to recognize abuse, how to intervene, and how to help get resources. And then every year we do celebrate, maybe is not the right word, but bring attention to all the women and children and relationship violence by participating in 1 Billion Rising. As well, we yearly recognize the murdered and missing women. And also December 6th, we will be either keynotes at different conferences or participate in the events that KPU organizes. And also, because we are trying to break down silos, on the left bottom of your screen, you will see a number of ministers. I believe 7 in total were able to attend. And that was something we were able to do with the Office of Domestic Violence in the last government. As well, we do a lot of media to try to increase public awareness. For a whole year, we did every Thursday on Red FM, third Thursday of the month, we would have a show, and we had various people appear from our group. We've written articles for popular magazines and newspapers. And if you are wanting to, you can also participate in that. If you're interested, just email NEVR and let us know. We've also contributed to some of the policy changes that have happened. A few of them we have there, and I think most of our audience is familiar with those. So I'm just gonna skip through that. The latest addition we did was to create a book, and it was based on what we were hearing from all of you, our members, to say, hey, we need something all in one place that gives us an overview of what's happening in terms of relationship violence. So this is a really comprehensive book with critical understandings around what are the different types of relationship violence, as well as some of the literature that surrounds all those areas, chapter on caregivers and burnout as well, as another one on law, and some on what can we do for prevention, and how does, what does some of the research say in relation to that. And you can get it for free. So we've got the website there. If you don't remember it, you can just go to kpu.ca/NEVR, and there's a link there as well. So to our work today, we're having this conference because survivors tell us they're not believed. They have to repeat their story many times. There are court delays. They feel like they're on trial, and they just want violence to stop. And this is the same thing we heard more recently when we did community consultations. We also heard it in 2011 when we did our first participatory action research study. So we want everyone here today to listen to what happens if a survivor is brave enough to call 911 and the various professionals they meet and the role of each other. What is the process in the Surrey court system or any court system? Some of the research around the challenges that survivors face. And what are some of the court models that are being used, and what are the benefits and some of the challenges that we find with them. So we want to listen carefully, discuss what may be good options for DV cases in terms of a court system. And then from our discussion, as you heard, we will create a report, and then it will be, first of all, it'll be shared with all of you. And then if there's anything you want to add, you can let us know, or if we've misrepresented something. And then we are going to ask all of you to also endorse the plan and the recommendations so that we can advocate and finally get a different court system that we've been asking for since 2011. And I know there's been a lot of changes, but there are still many challenges in the system as it exists today. And we want to be able to see if we can do better. So on behalf of the NEVR team, I want to thank you very much for joining us because only together can we create change. And if you can join our meetings, they will be remaining virtual, and there will be option to be in person as well. So they'll run both ways once we can get back into seeing each other in person. So please email us and let us know, and we'll be happy to work with each and every one of you. Thank you.
Thank you, Balbir, for that introduction to NEVR and how this conference will unfold. It's really useful. We're now moving into the first of the formal presentations, and this presentation is part recorded and part live. So I'm going to introduce first what happens when a person makes that 911 call. And this is Tally Wade, former KPU faculty and 911 trainer. And heads up, Jim, you're up next. So if Balbir could just show us that sharing again, wonderful.
Good afternoon, my name is Tally Wade. Today we're here to talk about what happens in going through the court system from the perspective of relationship violence. The first step would be the 911 call. Often the first encounter that a victim of violence in a relationship has with the judicial system comes when they make that call to 911 for help. This is the first step to what may be a very long and complicated process of navigating the court system involved in relationship violence. So what happens in a 911 call? First of all, let's define violence within relationships. They have distinct dynamics not found in other violent crimes. Violence often escalates and may continue or worsen if a person leaves or attempts to leave the relationship. Violence in a relationship encompasses married, common law, and dating relationships, and includes heterosexual and same-sex relationships where females or males can be the victims because there's a perceived or actual power imbalance between the individuals. This can include individuals who have been in a domestic relationship in the past, even though that relationship may not exist anymore. Things that are important to note is in the case of violence in relationships, calls to the police, a file must be created and can never be canceled by the 911 call taker. In this case, a police officer must be assigned to the call. Another thing to note is location is required to send help. So having a precise location, address, location within a house is really important to help ensure a faster response. I'd like to review some of the questions asked by the 911 call taker to help you understand why questions are asked and what will help you if you are a caller to the police. Is there any previous domestic history? Have police been called before? Have they attended before? This allows them to look into the history of the residents and whether or not it can inform the response. Are there any children in the residence? If so, how many? What are their ages and are they safe? If anyone has been assaulted, is an ambulance required? What is the nature and the extent of the injury? Often the call taker will keep someone who's been assaulted on the phone if possible to keep them safe and also to update officers responding to the scene. Also bear in mind the fact that the scene must be cleared by a police officer before the paramedics will attend to the person who's been injured. Another thing you may be asked is suspect description, whether or not they are preparing to leave. There are reasons for this. One is so the police can identify the suspect right away in case there are multiple people present, or if he or she decides to flee. Sometimes police arriving on scene may encounter the subject of complaint. If the 911 call is being made by a third party who can hear, can they tell what's being said? Are there sounds of violence, yelling, shouting? Does it sound like someone has been hurt? How many people are involved? Other questions you may hear are there any weapons in the residence? If so, what are they? Where are they kept? And does the suspect have access to them? If so, get a description. Is anyone in the residence under the influence of drugs or alcohol? Are they impaired for any reason? What is the relationship of the victim to the suspect? Are there any peace bonds or restraining orders in place under the BC Protection Order Registry System? These are updated within 24 hours, but in case there has a new peace bond, it's a good thing to know when the police are responding. Even if the caller states that the suspect has left the residence, the file is not downgraded, meaning the police will attend still as a priority call. Certainly because the suspect can return at any time. If the suspect has left, you will be asked for direction, time delay, mode of travel. Are they associated to a vehicle? If so, having a license plate and description of the vehicle and direction of travel would be important. Other things to consider. Are there any medical or mental health histories that may be related to the incident? And it should also be a consideration, and that information given to the 911 call taker. As previously mentioned, the call taker may continue to keep the caller on the phone even after the police have been dispatched in order to update responding officers. Because these are two different functions, the caller may believe that nothing is being done until the call taker hangs up. That is not the case. They can keep the caller on the line and be able to update information and reassure the person while the police are responding. Something else that might happen is the call taker may ask to speak to the suspect in order to keep them busy and away from the victim. If this is the case, the victim should attempt to stay apart and safe from the suspect. Is it possible to wait outside for the police to arrive? Or is there safety behind a locked door? Another thing just to remember is these calls are dispatched to the police as a priority and they cannot be canceled. The police will be responding as a priority call. I hope that you found this helpful and we look forward to having the question and answer period at the end of the presentations. Thank you.
Thank you, Tally. And as Tally mentioned, there will be a Q&A at the end. And although some of these presentations are recorded, all will be live for the Q&A. So next up to discuss the role of the police is former Delta Police Chief Jim Sesford. Jim, take it away.
Thanks, Jen. And thanks everybody for attending today. As Jen said, my name is Jim Sesford, formerly the police chief with Delta. I spent also 25 years with the Edmonton Police Service. And in both Edmonton and in Delta, I was responsible for creating the domestic violence units in both departments. I've been working now with NEVR for the last 15 years with Belbeer and several other members of the committee. And I take this as a very serious responsibility. Domestic violence is a serious and complex issue, and it's important that we understand the roles of everyone involved. As Belbeer had mentioned, domestic violence involves many different facets, different issues: sexual assault, physical violence, criminal harassment, uttering threats, mischief, damaging property, and financial abuse. And I think it's important to say to you that the province of British Columbia, as Minister Eby had stated, has taken a very strong position on domestic violence. And by the policy that they've implemented, they've given a very clear direction to the police and to the Crown. So the Attorney General and Solicitor General have adopted policy directives that require the police and Crown prosecutors to charge and prosecute all incidents of domestic violence where there are reasonable and probable grounds to believe that an offense has been committed. So this policy, in essence, removes much of the discretionary decisions for both the police and the Crown. So in fact, if grounds exist, charge is the way to go. If there are reasonable grounds, then we're to charge. Just quickly, Kelly had talked about 9/11, 911, and police response. It's important that I say to you that police response to calls for immediate assistance is very important and one of the most important functions of the police. Domestic violence calls in most cases require immediate police response. The police need to respond as quickly and as safely as possible. Normally, 2 or more police officers are dispatched to the call. And on arrival, police will exercise extreme caution to ensure that everyone is safe and that they eliminate any potential risk. They'll check for weapons. They'll check to see if there's any injuries, and they'll remove any potential risks, knives, clubs. They'll remove family or friends who may be standing by and who may be interfering and interrupting the police interviews with the victims. So the duties of the police when they respond to a call on arrival, the officers will initially separate the parties involved, and they'll interview them separately to determine what is transpired. Abusers often take offense to this. They believe that they should be there when the police are interviewing the victim. And what we found during these investigations is that oftentimes the abuser will make gestures or act in a threatening manner that inhibits the victim from giving a true statement to the police. So we'll separate the parties and interview them in separate rooms or in different areas so that the victim can't be intimidated. The police will conduct a thorough investigation. They'll submit a complete report, and they'll prepare the case for the Crown. And so the report then is submitted to the Crown. The police will gather all the evidence and they'll interview all of the witnesses. They'll take photographs of any injuries to the victims. They'll take photographs of any damage that may have been caused. If there's children that need to be interviewed, normally the police will contact the Ministry of Children and Families and have them respond and have them interview the children. The police, based on all this information they've gathered, they'll determine whether grounds exist for an arrest or for charges. They will arrest if there's reasonable and probable grounds to indicate that there's a criminal offense has been committed. They'll notify victim services. Most departments have trained staff and volunteers who can provide advice and become an advocate for the victims. And they'll notify the Ministry of Children and Families if there are children involved, where there's a risk to the children or where children are affected. The police must notify the Ministry of Children and Families, and they'll take a look after the matter from there. Any follow-up investigations, the files will be forwarded to domestic violence units within the departments. Victim services will work with the family if required. The file will be forwarded to the Crown and charges will be processed. Ultimately, the Crown will make the final determination on whether the charges will be laid. It's important for me to say that charges are laid regardless of the wishes of the victims. This removes the responsibility or the blame for the decision to lay charges from the victim. Oftentimes, the victim will recant and ask that charges be dropped. That is not the choice of the victim. The Crown will make that determination. Often what happens, as you're well aware, is the abuser will tell the victim that they promise to be good, that they won't repeat this kind of behavior, and they think that the charges should be dropped. And as I say, the Crown are the ones that will ultimately make that decision. And finally, what I need to say is that it's really important for the police to establish trust. The police receive extensive training on how to deal with investigations involving domestic violence. Offenders will often tell the victims that the police will take the children away, or they'll put the victims in jail. And what they do is they establish a feeling of distrust in the police. Therefore, it's of paramount importance that the police conduct their duties appropriately and they work toward building trust. It's essential that the police ensure the safety for all the people involved, and they work with all agencies to reduce reoffending. I hope this has helped. I will be around at the end of today's session to answer any questions. And thanks, Jen, for leading us through this.
Thank you very much, Jim. So our next presenter is Lynn Myatt of the Surrey Women's Centre to explain to us the role of support workers.
Yeah, okay to go ahead?
Yes, of course, Lynn.
Yeah.
Feel free.
Thank you for the introduction. Hello, everybody. Thank you for having me here today, representing the Surrey Women's Centre. Just a quick snapshot of the Surrey Women's Centre and our roles under the roof that we work from as support workers. Surrey Women's Centre is a crisis centre for women and children that are escaping domestic violence and sexual and physical assaults and other forms of gender-based violence. Surrey Women's Centre is the only community-based victim service agency within the Surrey areas, hence the very large population that we do support. Surrey also has the fastest growing city, it is the fastest growing city of Canada, with over 600,000 population. So the call statistics are very high. Surrey Women's Centre is privileged to have many programs under the one roof. But regarding victim services, we have in-house, we have the crisis team, we have the court team, and we have the SMART team. We have co-located teams, that's with the MCFD, and we have the RCMP co-located staff for the domestic violence unit and for the special victims unit. As a community-based victim service agency, we receive referrals from police-based victim services, and not just from the jurisdiction of Surrey. They come in from all demographics, as far north. We also receive self-referrals, hospital referrals, crisis line referrals, school counsellor referrals. Our imminent role as a crisis support worker is to provide short-term supports. We assess the needs, the risk assessments, and on doing a risk assessment, we do safety planning as well. We assist individuals with forms that can include income assistance, CVAP forms, housing, persons with disabilities, and also support, if need be, third-party reporting. We are also addressing barriers and accessing legal aid for the women and children in need. Our goal is to empower through collaboration, therefore meeting the woman where she's at. The crisis support team also support drop-in clients. So that's women, children, youth that turn up at the door and are in immediate crisis, and they are connected to a support worker in-house. The crisis team also answer the crisis line from 9:30 to 5. And this line is linked with Victim Link, who provides immediate resources for anyone who is not in an emergency situation. If a caller has experienced a sexual assault, physical assault in the past 7 days, Victim Link can connect the woman or child youth to the after-hours smart worker. So following on there from the conversation with the previous presenter about 911 calls, predominantly I've been requested to talk about the SMART call out. So the SMART acronyms is Surrey Mobile Assault Response Team. We respond to the hospital call outs 24/7. And this is the collaboration that we've just talked about previously, that this is a unique collaboration that we do have with Fraser Health and the forensic nursing team. So after a 911 call, but not always a 911 call, the SMART team are connected through an answering service with the forensic nurse. There is a time frame for us to get to the hospital pre-COVID. Presently, we are supporting victims through online FaceTime, which is working very well. So we meet as a team at the hospital, and we go together to meet the patient victim that's adhered to an assault. That whole process, when you consider that 911 call that they've already just gone through, they've just been a victim of a crime. They're now having to relay information. They're calling 911, that's very daunting. And now they're having to go through the hospital processes. So I'm just trying to sort of plant the seed about the timeline that each victim goes through. Not only just the timeline, but again, repeating the story. So already now, by getting to the hospital and being triaged, talking to the triage nurse, seeing the emergency doctor, seeing the social worker, and now they're meeting up in the forensic team. So they've already spoken about their story 4 or 5 times. When we meet up with the forensic nurse and the patient, it's a lengthy process, depending on number of injuries and the status of the assault. The nurses will do their due diligence and do their reporting and take all the information for the legal documentation if a file does move forward and go to the courts. For us, as a SMART member under the jurisdiction of the Surrey Women's Centre, we're huge emotional support in the moment. And then post-hospital, we are the community support for the individual. After the nurses have done their paperwork as a SMART worker, we then do our risk assessment, which is also quite lengthy. During the conversations and listening to the story, our expertise is really assess the risk and sort of looking for the high risk offenders. We are dealing at times with life and death situations. Following the risk assessment, we then will do our safety planning, and that can take a different time of duration of time depending on the risk of the file. Also, when we're called out, upon consent from the patient, we also will support them during the forensic exam. The forensic exam in itself can take as many hours, from 2 to 10, 12 hours, depending on the number of injuries that are being documented. I do apologize, I keep getting somebody trying to come through. Our lens is post-hospital as well. The agency, like I mentioned, that we've got many different programs. So that file will be then allocated to either the court team or MCFD team or the domestic violence unit or the special victims unit, which is youth sexual assaults and stranger sexual assaults. And those files will be held until as long as need be for the duration of the judicial system. I think that's all I can give insight to sort of following that 911 call. There is a timeline of 7 days when a woman is seeking forensic examples to support her file. The forensic nursing team can hold the specimens for 365 days, but the paperwork obviously is lifelong. There's 3 levels of care that is offered. It's not necessarily that because the woman has called 911, she might be with a police officer at the hospital. She may choose to move forward. She may choose to drop charge. So we're there to support too for the women if they need to give their statements, to be the advocate, to be the buffer, to support them through a very trauma-informed journey of healing after such heinous crime. I will be available for the Q&A at the end, so I look forward to the discussion further on. And I think my team member will be talking on Friday about the court team as well, more specifically for the conference.
Thank you very much, Lynn, and thank you for the work you do and everybody is doing here. So next up is Priscilla Belonio, who is going to talk about the role of transition houses. Priscilla works at As Your Place in Delta. And I believe this is video, but Priscilla is in the room with us for Q&A later. So we're just waiting for that video to start.
Yeah, Jen, it's actually Sheila is going to talk about the role of the forensic nurse before the transition house.
Oh, my apologies. I'm looking at an old version. Okay, Sheila, please introduce yourself.
No, I've got hers here.
Hi, I'm Sheila Early, and I'm going to detail the role of the forensic nurse examiner in the care of an individual who presents to healthcare post-sexual assault. If this center that the individual presents to has a specialized program, often known as a forensic nurse examiner program, there will be individuals that are available on call to come and care for that individual. First, they need to be cleared medically to make sure that there isn't any life-threatening or injuries that need to be dealt with. And which means that they may need to see a physician if they are triaged to have an injury. For example, they're bleeding profusely, or there is an injury that needs attention immediately. However, that is not usually the case.
Albir, we've lost the sound.
You can't see the picture either, so I'm just trying to redo it. Okay, Jay, what am I doing wrong here? I'm doing everything I've been doing for the last few. Share sound, share screen.
Share your screen first, Balbir, then sound.
Okay, yeah.
Now we're looking at Sheila and Poppy's.
There we go.
Hi, I'm Sheila Early, and I'm going to detail the role of the forensic nurse examiner in the care of an individual who presents to healthcare post-sexual assault.
Can you hear it now?
If this center that the individual presents to has a specialized program, often known as a forensic nurse examiner program, there will be individuals that are available on call to come and care for that individual. First, they need to be cleared medically to make sure that there isn't any life-threatening or injuries that need to be dealt with. And which means that they may need to see a physician if they are triaged to have an injury. For example, they're bleeding profusely, or there is an injury that needs attention immediately. However, that is not usually the case in over 95% of the patients. The nurse examiner is a specially trained individual who is trauma-informed, objective, non-judgmental, unbiased, and also culturally sensitive, trained, so that they are well aware of the violence and trauma effects on individuals. The nurse examiner will speak with the individual and provide him or her with options that include first having a medical examination only, which means that they would be dealt with as far as any medical care that is needed, any resources that are needed for follow-up in the community or within the healthcare facility itself. The second option would be for a medical examination, as well as forensic evidence samples collected with permission of the individual. And these samples could be stored for up to 1 year, depending on the individual's choice. The third option is to have a medical examination done, to have a forensic examination where forensic samples are collected, and then the patient gives permission for the samples and reports to be turned over to the law enforcement agency or in that jurisdiction. Each of those choices are explained fully. The role is to make sure that informed consent is absolutely necessary, that the individual understands the whole process and at any time can withdraw their consent for any part of the examination. This is very different than what it used to be when I first started working in the emergency departments many decades ago. The individual also is linked with resources within the healthcare facility, if it's in acute care or in the community, for follow-up. So this might be a women's center, this might be a social worker, it might be any individuals where they need a transition house, or if they need someone to come, etc., and care for them after you take them home, etc. So those resources are fully known by the nurse examiner, and after the patient has left the hospital and has safely left the hospital, that's another thing, is that the nurse examiner completes a complete documentation on the events that she has recorded, and they are filed. If the patient has chosen not to report to police, that documentation is stored indefinitely. Samples would be saved for 1 year, unless they're directed to be saved for longer. At any time the patient chooses to report to law enforcement, the documentation will be present. The last part of the nurse examiner's role is to testify in court, usually as either a fact witness or as an expert witness, if and when there is a criminal process following after, could be many years. So that is kind of the last part of the nurse client-patient relationship, where the nurse examiner does testify in a court of law. Overall, the examination will take approximately 3 to 5 hours, some longer, some shorter, and the patient will receive care for any medical events that may need attention. For example, emergency contraception, antibiotics, hepatitis B immunizations, HIV prophylaxis, as well as any other medical conditions that might come up that are urgent and related to that specific incident. Overall, since 1994, there have been thousands and thousands of men, women, and children examined by nurse examiners here in British Columbia, and I'm very proud to have been one of them. Thank you.
Thank you, Sheila. Okay, now I'm going to introduce Priscilla Belonio from As Your Place in Delta, because many survivors cannot stay in the home that they were in. Many end up having to use the facilities of a transition house. And Priscilla is going to explain that to us. Just giving Balbir a moment to share her screen.
My name is Priscilla Belonio, and I am the house manager for Azure Transition House. The role transition houses play when a woman is fleeing domestic violence is very crucial to her healing process, to gain strength and live independently and to move forward with her life. Transition houses are a short-term, confidentially located houses providing services to women and children who have suffered domestic violence or at the risk of violence. Residential services and crisis lines are offered 24 hours a day throughout the year, providing women and children advocacy and support to help them regain their self-esteem and rebuild their lives. At our transition house, we offer the following services. Basic needs. These are the things that our clients would need when they come to the house, the initial intake. Obviously, they don't have any time to gather their belongings when they leave their house. So we provide emergency care kits, clothing, and other things that they might need. We also provide safety planning. It is very important that they are to exercise safety when they are in the house or when they are leaving the house. Legal help. Our outreach worker will help the client apply for legal aid to help her in her case with the child custody and or restraining order or protection order. Income assistance. It is very important that they apply for income assistance to help them get funding as soon as possible so that it will help them find accommodation or other expenses that they may require. Counseling and education. It is very important for the client to know more about what is domestic violence, including the cycle of abuse. We offer also services for children. They are also offered such as the PEACE program. PEACE program stands for Prevention, Education, Advocacy, Counseling, and Empowerment. This program is for children and youth that have been exposed to or witnessed domestic violence. There are other services that they also may require, and these are writing resumes for job applications, schools for them or their children, English as second language, and others. Second stage housing program. This is a program that is offered after they have left the first stage, which is the 30-day stay at the transition house. If they would require more advocacy, referrals, or continuum of care, then they can apply for the second stage housing. The second stage housing is approximately 9 to 12 months, and the resident support worker will assess their needs and their goals and will work with them on a weekly basis. WISH's support groups are also offered while they are at our second stage housing program. WISH's stands for Women in Safe, Healthy, Empowering Support. They can be connected to different agencies for future support groups after they have left our second stage housing program. Towards the end of the program, the outreach worker will help the client find housing, or hopefully BC Housing application has come through for them and that they have given them accommodation in the area that they have chosen. There is also an affordable housing that they can apply if there is an opening. And what is an affordable housing? Affordable housing is for people who can apply, who have low to moderate income, but may not be eligible for subsidized housing, such as cooperatives with housing listings. Well, this is it for now. Thank you so much for giving me the opportunity to present the role of transition houses in the community for people that are fleeing domestic violence. I hope that you find the information helpful and stay safe.
Thank you, Priscilla. Next up is Pam Batty, who specializes in criminal law, and Pam is going to explain the role of Crown Counsel. And here we go.
I'm here to talk about the role of Crown Counsel in instances of intimate partner violence. In cases where the police have attended and investigated and feel charges are warranted, they forward to Crown or report to Crown Counsel, which includes a summary of the evidence that they've collected, any statements, photographs, whatever has been a part of that investigation. Crown reviews that information and determines whether it meets our charge assessment standard, and if that's the case, then charges are laid. Usually, if there's not a history of domestic violence, the accused is released on conditions which will include no contact with the complainant. After this, they will retain counsel or speak with counsel and determine whether they want to lay charges or whether they will, after this, they will typically retain counsel and determine whether they want to plead guilty to the charges that are laid or whether they wish to plead not guilty. If there is an intention to plead guilty, this is where the role of defense counsel can come in and be of great assistance. If the overall intention is that the accused person will ultimately plead guilty, there may be some time taken for that person to show good bail performance, to show that they have taken steps towards rehabilitation, to put themselves in the best position they can before the court so that they may get the best sentence that they are able to get as a result of their plea. Within this process, Crown Counsel will, after the bail hearing, initial bail hearing, contact the complainant in the matter and just check on them to see how the bail conditions are working for them. This is called an ADIV or an advanced interview. And this is not an interview to prepare them for court. It is one where Crown Counsel will speak with the complainant, determine whether the bail is working for them, whether they need changes to the bail, and if that's the case, at the very next appearance, we may agree to changes to the bail that are of assistance to the complainant. Throughout this process, there is the involvement of victim services, who assist with supporting the victim, helping them learn about what's going on if they aren't able to get that information from Crown immediately, and just keep them connected to any services that they may need within the community. The accused person will make a number of appearances in what is termed Courtroom 104 or intimate partner violence court in the Surrey courthouse. If they determine that there's going to be a trial in their matter, then a trial crown is assigned to that matter and the matter will proceed to trial. Within that trial preparation process, Crown will meet at least once with the complainant to prepare them for court, review statements, go over potential questions that may be had from defense counsel, as well as answer any questions they may have about the trial process, what will be likely outcomes, what Crown will be seeking by way of sentence, and then have some input with respect to what they want as support from the court system. If the accused person chooses to have a trial and are found guilty, then the complainant has the opportunity to present a victim impact statement. This is not a statement about the offense itself, but about what the impact of that offense has had on them. You know, as a result of the injuries, they may not have been able to work. As a result of the accused not living in the home, he may have stopped paying mortgage payments, causing the complainant to have difficulty maintaining housing. These are a number of the issues that may come up in a victim impact statement. And all of that is considered by the court when determining a fit and appropriate sentence for an accused person. At the end of this process, the complainant will still continue to have victim services and can continue to contact the Crown if for some reason, if there's probation conditions, those conditions are no longer working, you know, there's a family court proceeding and the particular conditions that were sought are getting in the way of the family trying to move forward. Perhaps they've now reconciled and they'd like to speak again about the no contact conditions. All of these things are things that Crown Counsel can assist with respect to the trial process and the intimate partner violence charges that are before the court.
Thank you, Pam. Now we're moving on to Defence Counsel, and Rob Danu, who is a former Crown Prosecutor, will explain the role of that office. And we'll hear from Rob just as soon as we can get the video available to us all. Whilst we're waiting for the video to get started, I just want to mention that for those of you who might be interested, there is a certificate of completion for attendance at this conference available. Some of you might need to benefit from that in a portfolio. I think we have the video now.
Good morning or good afternoon, depending on when you're watching this. My name is Rob Danu, and I am a criminal defense lawyer. I'm here to speak to you about this extremely important topic, ending violence in relationships, as well as the role of a defense lawyer in our justice system when it comes to cases of domestic abuse. Thank you, first of all, to Kamalji Lehal, Balbir Gurm, and Jennifer Marchbank for asking me to speak on this extremely important topic. We know that in terms of domestic violence, the pandemic has made this issue more pressing than ever before. As a criminal defense lawyer, I've seen cases of domestic violence on the rise due to social isolation and quarantining, and it's an issue that we'll be grappling with in terms of the impact of the pandemic on domestic violence for many years to come. When folks ask me about my role as a defense lawyer, I often relate to them the analogy of an emergency room doctor. For instance, when someone shows up in the ER with gunshot wounds, it's not the job of the doctor to ask whether this person is rich or poor, or whether they have high status in society or low. Rather, it's their job to diagnose and treat. And that's the theme of what I'll talk to you about here in these next few minutes, is the role of a criminal defense lawyer in diagnosing and treating their clients. Regardless of innocence or guilt, my job is not to judge my clients on a personal level. My job is to begin by diagnosing them. Why are they in my office in the first place? What is their story? Trust me, no one comes to see me for fun, except maybe my 5-year-old who still thinks I'm cool for some reason when I'm actually not. In terms of human nature, we have to understand that very few people are born psychopathic, where they're predisposed to inflict violence on others. Rather, in terms of diagnosis, my job is to ask why. What are the underlying issues as to why they've been charged criminally in the first place? Have they been a victim of abuse or witnessed abuse in their past? Are they now exhibiting those same behaviors? Do they have issues of addiction, of mental health, behavioral disorders? Are there other stressors in their life, such as financial, emotional, or any other factor that could play a role in terms of why they've been accused of doing what they're doing? Is it some of these issues, or is it all of the above? Now, just like that ER doctor, once the diagnosis is complete, the next step is to formulate a plan to treat it. And once again, this is regardless of innocence or guilt. The fact that this individual is in my office almost always means that there's some form of professional assistance that can be helpful to them, both in terms of their legal problem as well as the underlying life issues. The end goal that I have as a defense lawyer is to make sure that when that client's file is over, in terms of their legal problems and their life problems, they're in a much better place than when they first walked into my office. What I find as a criminal defense lawyer is that this pot has been boiling for quite some time in terms of the underlying issues that the client has. And now the pot is finally boiled over. These individuals that we deal with as criminal defense lawyers have often never even taken the first step to attempting to understand their underlying issues. And we are, as criminal defense lawyers, the conduit to that understanding, to allowing them to have access to the resources they need to be in a better place. And what we find is that oftentimes the victim also has many of the same issues, whether they're addiction issues, whether they're anger management issues, and oftentimes both the accused and the victim can benefit from the same type of counseling. And this is important because in terms of my practice, I represent not only individuals accused of domestic violence, but also victims of domestic violence, both in terms of sexual abuse as well as domestic abuse. In terms of sexual abuse, defense lawyers make applications to be able to cross-examine a victim on their past sexual history, or to have access to private records such as diaries or counseling records. And my job is to oppose those applications to protect the privacy interests of my clients who are victims of abuse. In terms of the domestic context, oftentimes domestic victims do not want to speak to the police, are anxious about talking to Crown, are unable to have a voice without the assistance of counsel, and we help on that front as well. And so the theme that guides me in my role as a criminal defense lawyer is to try to help and to try to heal my clients. My job is not to add fuel to the fire, but rather to try to put that fire out. Now, this does not mean that there are not trials and that there are not intensive cross-examinations of individuals accusing clients of domestic or sexual abuse. Oftentimes, these types of cases are some of the most contentious and dramatic cases, full of emotion, full of relationship history. But the end goal is not to fight for the sake of fighting. Rather, the end goal is to try to help, is try to heal. And if there's no alternatives, the end goal is to protect the rights of our clients, whether they are the accused or whether they are the victim. I hope this helps you in terms of understanding the role of a criminal defense lawyer, and thank you very much for listening.
Thank you, Rob. Moving swiftly on, I am delighted to introduce Judge Catherine Ferris, who will explain the role of judges. So we're still waiting for that video to come up. And so I'll just let you know that although we're running a little late because of tech, we will be having a break.
My name is Catherine Ferris, and I'm a judge of the Provincial Court of British Columbia. I am here to discuss my role in making protection orders under both the criminal law and family law. There are a couple of things you should know before I start. First, as a provincial court judge, I'm only able to apply the law as set out in legislation, and then only legislation that I've been given the authority to make a ruling on. The second thing is that lay people often think that I know everything about them, including the number on their last income tax return, and I don't. I don't have the police report to Crown Counsel, and I will not have the criminal record of the accused unless I am given it. If I am in a criminal court matter, I will not have the family file, and if I'm in a family matter, I will not have the criminal file. And I will likely only know there's another file if someone tells me. So first, I will deal with orders made under the Family Law Act. Family violence may be physical or sexual abuse, but it can also be psychological harm through intimidation, restrictions on a person's financial or physical autonomy, or intentional damage to property. For a child, family violence also includes indirect or direct exposure to family violence. Under the Family Law Act, I am able to make orders protecting certain people who are called at-risk family members from other family members who are committing family violence. For the sake of convenience, I'm going to just call the at-risk family member the applicant and the other family member the respondent. The situations where I may make a protection order are sometimes fairly obvious, such as a protection order between the applicant and their spouse or former spouse, or someone that they have lived with or are living with in a marriage-like relationship. But I can also make protection orders where the respondent is a parent or guardian of the applicant's child, and even if the applicant and the respondent have not lived in a marriage-like relationship and they are not spouses or former spousals. The restriction on that is that the child has to be under the age of 19 because that is the definition of child in the Family Law Act. So unless the relationship falls into one of the more obvious categories, I find it a lot easier just to look at the legislation and the relationship between the parties and determine if the legislation gives me the authority to actually make a protection order. There are different ways a person can apply for a protection order. Sometimes a person will come to court and ask me to make a protection order without any notice to the other side. Without the other person there, I'm making an order that may restrict a person's parenting time with their own children without knowing all the facts. I have to decide on sworn evidence whether the matter is so urgent or dangerous that the risk of making a wrong order is less serious than the risk of making no order. Often, I will decide to give the applicant a shorter period of time in which to serve the respondent rather than making a protection order without notice. And factors that I consider are whether there are criminal orders already in place, if the applicant is in a safe place, such as a transition house, and also how urgent and dangerous the situation is. There are some situations where people tell me things that make the hair on the back of my neck stand up, and I usually take notice of that. I also look at whether the separation of the parties is recent, whether the family violence is repetitive or escalating, and whether there are mental health or substance abuse issues. The applicant themselves may be more vulnerable, such as being in poor health, or older, of course, or pregnant. The protection orders are prepared by the court, signed and entered by the provincial court judge, and put on the protection order registry before the end of the day. And that's so that they're available to the police in case there's a situation that arises. Court Services has contracted with the process server to make sure that those protection orders are served, and breaches of the protection order are enforced only through the criminal justice system. So it becomes a charge under the criminal justice system. Sometimes the situation is more of an apparent inability between the parties to communicate respectfully to and about each other. And in those cases, I would typically make a conduct order instead of a protection order. Conduct orders under the Family Law Act usually just put limits on how people can talk to each other and what they can communicate about. Some of the conduct orders state that the parties were to put the best interests of the children first and encourage polite, respectful communication in front of the children, ensuring that adult matters such as court are not discussed in front of the children. Conduct orders are not enforced through the criminal justice system the way that protection orders are, but they can be enforced through provisions of the Family Law Act, through fines or the making of posting of security. I'm now going to discuss my role in making protective orders in criminal court. Those orders include protective provisions in release orders, probation orders, and Section 810 recognizances, which are also known as peace bonds. Release orders are often called bail orders. I find release orders are sometimes the most difficult decisions that I have to make. The decisions of the Supreme Court of Canada have confirmed that I have to release the accused on bail at the earliest opportunity and on the least onerous restrictions that will keep society as well as any particular person safe, such as the complainant or their children. And that is because the accused, of course, is presumed innocent until they're proven guilty. When considering whether it is safe to release someone on bail, I look at the same factors I would for a family law protection order, but I also have to look at the seriousness of the alleged facts, to some extent the strength of the Crown's case, and the person's criminal history that is set out in their criminal record. But often a person accused of family violence has no criminal record, and they can be law-abiding citizens until they get home. So when I'm considering whether they can be released, there is very little for me to go on. And often I am just left with having to release them, assuming that they will follow the terms of the court order that I place them on. Often I don't have much information at that point from the complainant because there may not have been much of a police statement taken even. So in that situation, the accused is often released on the same terms that are similar to the terms of the family protection orders. One of the key differences between the criminal protection orders and the family protection orders is the group of the relationships between the parties, if I can call them that, the complainant and the accused, or the applicant and respondent, as to who can be protected. And of course, in criminal orders, anyone can be protected through a protection order as long as it makes sense. But on the family ones, I am restricted to what the Family Law Act says about what relationships I can make protection orders for. Thank you.
Thank you, Catherine. And finally, we're moving on to what happens after conviction and the work of offender services. And this will be explained by Harpal Joel. And after Harpal, we'll have a short Q&A.
Hello everyone, my name is Harpal Joel. I'm working with the Option Community Services as a program manager for Domestic Violence Intervention Program. Today I will be talking about various resources and programs available for perpetrators and clients who are at risk of abusing their partner. The first program I would like to talk about is Domestic Violence Intervention Program at Option. Program provides services in Surrey, Delta, White Rock, and Langley areas, and MCFD funds this program. Only social worker can refer clients to this program. Program provides services to male, female, and LGBTQ perpetrators. Program provides individual counseling, group counseling, and group counseling. Program runs Caring Dad Group. Caring Dad Groups has 17 sessions. Caring Dad Groups are available on Tuesday and Thursday in the evening time in English language. Program runs Caring Dad Group on Sunday in Punjabi language. For more information, please contact Harpal at 604-809-5742. And next program is a Respectful Relationship Program. This program has 10 weeks education group. This program is co-facilitated by male and female probation officers at community correction officers. This is data program only for probation clients. Next program is a Relationship Violence Prevention Program, or RVP program. So this program has a 17 weeks group program. This program only accepts referral from probation officer. STRO Health provides our relationship violence program throughout the province. For more information, please contact STRO Health at 604-948-4912. So our relationship violence prevention program also have a culture edition. Under culture edition, program provides services in Hindi, Punjabi, and Urdu language. Sometimes certified interpreters are also available for additional language. For Surrey and Vancouver area, please contact Mosaic Community Services at 236-521-7081. In Abbotsford area, please contact Archway Community Services at 604-859-7681. Enhancing Healthy Relationship Project. So this program is available to immigrant, refugee, and visible minorities couple who are at risk of experience or perpetrating domestic violence. Program accept self-referrals, and this program has 8 sessions, 7 couple sessions, and 1 follow-up session. For Vancouver and Surrey area, please contact Mosaic Community Services at 236-521-7081. Men in Change. This program is available to immigrant, refugee, and visible minorities for men who have used or are at risk of using violence in a relationship. This program accepts self-referrals. Programs are available in Vancouver and Surrey areas, and program provides services in English, Hindi, Punjabi, and Urdu language. Certified interpreters may be used for additional language as needed. This program in Vancouver area program also provides individual session during office hour and group session in the evening or on the weekend. Men in Change program is also available in Surrey area, and program provides services in English and Punjabi language. Certified interpreters may be used for additional language. The program has 12 sessions, and the program is available during evening and also on the weekend. And for more information, please call 604-317-7847. Courtyard for Men program. So this program runs by Archway Community Services. This program has 8-week psycho-education group. Program provides services in Punjabi language for immigrant men. For more information, contact Archway Community Services 604-743-0404. Delta Assist also provides programs for men and women, and the program name is Anger Management and Healthy Relationship Group. This program has 12 weeks program. Delta Assist also runs Caring Dad Group. Caring Dad Group has 17 weeks program, and for Caring Dad program, participants must have some regular supervised or unsupervised contact with at least one of their kids. For more information, please call Delta Assist 604-594-3455. Rebuilding Family Relationship Program. So this program runs by Family Services of the North Shore. So this program has 12 weeks. The program provides services in English and Farsi language. Program accepts self-referred. For more information, please call Family Services of North Shore at 604-988-5281. Mentor, Men Transforming Relationship. This program has 15 weeks program. Program accepts self-referrals. Program is available in Newest and Tri-City areas. For more information, please contact Margaret Hart at 778-735-0260. Thank you very much for listening the presentation.
Sorry. Thank you, Harpal. I'm very conscious that we have a little, we're running over on time, but I would like to offer an opportunity for anybody who has a question to either raise your hand, use the reaction button to raise a hand on screen. If you just do it physically yourself, I won't necessarily see you because there are 4 screens of you. One question was put into the Q&A, which was with regards to 911, do people ask the caller if they've been strangled or hit in the head? Because often victims do not consider those 2 injuries to be injuries. I just wondered if Tali, you would like to comment on that.
Okay, not specifically. Again, there would be an assessment as to whether or not there were injuries and whether or not an ambulance is required.
Thank you. Is there anyone who would like to ask a question or seek clarification?
Can I ask further to that? That was my question. I'm Hannah.
Yes, Hannah, thank you. If you wish to follow up, please do.
Hi. I'm a nurse practitioner working with forensic team. What we know about strangulation is that many women don't realize how serious it can be, and they think of their sprained ankle as their main injury when actually strangulation may be really serious. And what we're learning from a lot of research, specifically in the United States, is that if we don't ask, they won't tell. I'm wondering, Tali, if there's a way we could request that the 911 dispatch specifically ask about strangulation and head injury, because it's something that if you say, are you hurt? They'll say, no, I'm fine. And yet they may have been strangled to unconsciousness and not even sort of realize that they may actually be serious. I'm wondering if that's the possibility of ever having that added as a very specific question. Was anything placed around your neck? Did you lose consciousness? Was anything hit on your head, or did you hit your head? That would require medical.
Good suggestion. It's something that we could put forth, I would imagine. I don't make the decisions on the how the calls are assessed, but certainly given your research, I think you probably would be able to make a case for it. Jim, do you have anything further to add from the police perspective?
Yeah, thanks, Tali. During their investigation, as I said earlier, the police will do a complete investigation. They'll ask all those questions about what injuries, if any, you received, what happened, how did the assault occur? So they'll have all of that information available to them. And I think, though, that what happens, of course, it's all contained in the report. They'll send the victim off to the hospital for treatment. But I'm not so sure that information is shared by the police with the medical staff. So that's something I think also the police need to be aware of. I can also say at the last conference, I listened to the nurses talking about strangulation and some of the other impacts that they're seeing with victims of domestic violence. And it was really quite informative. And I'm hoping that maybe in future conferences, we can have a further discussion about that and draw the police in so they can hear hear some of the things that the nurses are talking about.
So another question has come in from Joanne. Joanne, would you like to ask that yourself? You are on mute.
Sorry, I wanted to ask Jim about the extensive training he talked about of police officers in order to, handle sensitively the call that they get for domestic violence. Could you comment on what kind of training that involves, including the length of time spent doing that training?
Certainly, I'll do that. We, when the police officers when we're in training at the Justice Institute or in other police agencies, during that training session, we receive training on handling domestic violence and you know, how the investigation should look and the various steps in the process. The province has also put together an extensive online training program. And I know the last time I took it, it took, it was about 4.5 to 5 hours of video. We talked about different steps in the process, what the police needed to be cognizant of. And then what came with that was a question period where they talked about, what did you see in the video? What are the steps that you needed to take under these certain circumstances? So I can't get into all of the questions. It's been some time now since I took that course, but it was extensive, and everyone in policing was required to take that course, that online course, and as well get it while they're in training at the Justice Institute.
Thank you, Jim. I'm going to do a last call for questions. Suki, would you like to come in on camera?
Yes, I'm on camera right now. I had a question for our honorable judge. Recently, one of my domestics, the no work condition was taken off, no go to the no work. And I was just wondering, the odd time I see on domestics a no reporting condition, and it really catches me off guard when I see that. And the latest one where I seen a no go to the workplace, this couple in particular, they work together at the same site, different jobs. And with the no work taken off, it has created a lot more problems at the workplace that she has to now deal with. And I'm just wondering, how would that be taken off without her consultation, as it was done in this particular case?
Judge Ferris, are you still with us?
I am. I'm sorry, and I missed the question because I got an email and I lost my train of thought. So I could hear it again.
Okay. So one of my recent domestics, the no go to the workplace in particular was taken off. The couple worked at the same location.
Yeah.
And it really caught her off guard. It's created more barriers at the workplace, just more issues. A lot of stuff has been happening. And now she's having to go through the workplace to handle those matters. But they wouldn't have been created if he hadn't gone to his defense lawyer and had the no work condition taken off. So I'm just wondering, why would something of that nature have gone forward through court without her consultation?
Well, it wouldn't have been the judge that would have consulted. We probably were told that that she had been consulted. I don't think, like, I would never, like, I'm speaking for myself, but we don't usually change bail terms unless they're with the consent of the Crown, who would have spoken to her. As far as at least in my own way I do it, because I appreciate how dangerous these things are, and I appreciate Crown knows how dangerous they are too. So I'm not sure what happened there.
Okay.
I don't know if I was the judge on that one or not. It sounds,
no,
somehow sounds familiar, which makes me a little nervous, but yeah, it would have been because I was told that. I think. I just can't remember if I don't think I would have ever made a decision like that without being told something.
And maybe if our Crown could comment on that, like, would a question of that nature, so say defense said to them, you know, they work at the same place, they need to communicate, would you agree with that and automatically and say to defense, yeah, let's go ahead and change it, and then she has to bear the consequences later and she wasn't notified? If you can comment on that.
Well, I know in cases like that, if it's Pam Batty, in cases like that where defense may have come with us saying, look, he's not able to work, they work at the same site, usually I would be looking for some assurances from them that they're working in completely separate areas, they don't normally have contact with one another, or there's always a lot of other people around. Like usually we're giving some representations like that. And that really speaks to the hardship on the accused person. You know, he can maintain the no contact, but he needs to be able to go back to work, that type of thing. And so we don't always consult if it's clear from what they're telling us, you know, oh, he's on the 3rd floor, she's on the 8th floor, you know, something like that, where it's totally different, where it's a totally separate workspace. That may be one thing. So, and I don't know about your case specifically or what might have been said to the Crown on that, but certainly if you have concerns or if the no contact is difficult to maintain, despite the changes, it's always worthwhile to reach back out to the Crown and say, look, you guys made this change and this is how it's impacting the complainant. And then even if we don't go back and do anything about that bail because there's no opportunity to do so, it may be something that can be addressed at a different point, either at sentencing, or if there's a bail breach, then we can go back and revisit whether that bail condition is still appropriate.
Thank you. I'm very conscious of our time, and I'm going to finish us up here for now. If you have further questions, you can always stick them in the chat and we can get answers for you. Before we move on to our keynote speaker, Vincent Sason, I would just like to say that I think we should take a 5-minute break. So if everybody could come back here, let's say at 12 minutes past 3, I really do advise you to get up, walk around, go get a drink, and come back in 5-6 minutes. Thank you. I'm going to move directly onto our keynote speaker, Winston L. Sason, QC. He does say he's retired, so I think that might be quite proud of that retirement. Winston, thank you so much, and our apologies for overrunning.
Thank you for having me here. And Jennifer, thank you for being so merciful in allowing us this break. I know how hard it is to listen with a full bladder. So thank you for the break. And here I am. I will promise to do my best to end by 4 o'clock. So I'll just truncate my materials. Yeah. You
So
know,
Winston, are you sharing your screen with us?
I will later on. Yes.
Okay.
I just want to know that we are all here because we wish to honor all of those who have suffered in the hands of violence inflicted by intimate partners. And what is truly mind-blowing is that all it takes is one man to abuse and beat a woman, but it would take an army and a community of people to make things right and to restore her sense of well-being and her equality in our community. When I say it takes a community, we're talking about the police that respond, the paramedics that attend, the forensic nurses that look after the victim services, transition homes, prosecutors, court staff, probation, correction, judges, all because of one person abusing a woman. Multiply that by what we see. In fact, in Surrey, we have the domestic violence unit, to which my colleague Pam Batty is one of them. They take up to 30% of the caseload in Surrey. That is the reality of our situation. And there is great sorrow on my part to retire, knowing that, wondering if I had made a difference in this evil of domestic violence. And sometimes those of you who have been in this line of work for a long time, that is a question that we would ask. So what I'm about to share with you is 30 years encapsulated, briefed into 45 minutes. What happens in court? And what comes from court must come from in order to understand what happens in court is we need to understand the roles of the key actors in court. For example, the judiciary, the Crown, the defense, and all other parties. And I'm very grateful for the previous speakers that spoke during the panel, for you have made my job easier. My presentation will be sprinkled with personal anecdotes to help illustrate and animate the points I'm about to make. You will be hearing the perspective of a person who has been in the front trenches for 30 years, where I have seen justice done, and sometimes I wonder if justice was done. I am now retired. I have great freedom to speak my mind, and I will speak my mind. You are hearing from a person who has been wounded from the repeated exposure to the harm and trauma done to others. My suffering does not come even close to that suffered by the women who have gone through intimate partner violence. Now, I say women because it is, in my case, 98% of my files are women, and I acknowledge that there are same-sex abuse and there's abuse of women against men, but for purposes of today, I will be using the word women. I will be giving you examples of some of the files I've prosecuted, and some of them will be disturbing. And for those who have gone through domestic violence, or those who may be triggered by what I'm about to say, or who are not ready to hear this, please give me 2 minutes. Please turn down your volume. And when I finish talking about these specifics and details, I will do this so that you could come back. When we talk about this, we hear about statistics, we hear about the prevalence of domestic violence, and I will share with you the glimpse from a guy in the trenches and what kind of violence we see. We see tremendous amount of degradation of women. For example, in this case, I prosecuted the accused forced the victim to have her tattooed in her pubic area, the property of JB. And she did, and the female tattoo artist did. Another male, because he was so insecure, his girlfriend came home late and he accused her of screwing around, of fucking somebody else. And to punish her for that, he shaved off her golden hair, shaved off her eyebrows, cut off all of her eyelashes. Why? To make her ugly so that she would not be attractive to other men. This is an example of the kind of things that women go through. I had another case where the victim wanted out of the relationship, and the accused said, no, you're not, because if you do, you will get it. And in fact, he made her write lines on the paper. I will obey Mike. I will obey Mike until her arms are sore and until he said stop. She finally got the courage to say, no more, I'm out of here. And in fact, she, in an act of defiance, said, in fact, I'm going out and have somebody screw me in the ass. And for that, she got stabbed 26 times. Not all cases are of this degree seriousness, but these are the examples of what will happen if domestic violence is not checked. At certain points, it would escalate. And in fact, we do know it escalates because one of the highest rate of murders are domestic murders. The cruelty involved in domestic violence is brutal. I have not ever imagined the kind of torture that men have inflicted on women. They include using cigarettes and to burn the armpits of the victim. And she explained to me that he did that because A, nobody can see it. B, it inflicts maximum pain. This is real. These are the things that will drive us and to encourage us, to sustain us, to do as much as we can. It is a very dark and evil world. I am done. For those who have muted or turned on their volume, please come back. I wish now to share with you very important principles that govern what we, the prosecutors, do in court. And to understand what we do, we need to go back to the fundamentals. And for some of you, I understand are academics that teach this. And there's some that are students that are new. So please bear with me as I explain the 4 fundamental principles of the criminal justice system in Canada. First, there is the presumption of innocence. That is very important, and that informs why people who commit violent crimes are out on bail, because the Charter of Rights guarantees that they must have reasonable bail imposed and that they are presumed innocent. And because of their presumption of innocence, everything we do, and that's the second point, the job of proving it is on the Crown. The burden of proof is on the Crown, and really not me. I mean, when I go to court, I have nothing to offer the judge except the testimony of the witness properly prepared by me, and to present arguments and to marshal demonstrative evidence and real evidence to establish the crime. So when you say the burden of proof is on the Crown, it is my job to get that done. And primarily, my job is to equip the victim or the witness to do their best job in court. The burden of proof never ever shifts to the accused. The accused has no need to explain why she has blood covering her eyes and why her fingers are all broken and mangled. He doesn't have to explain a word. And when he asks for a lawyer, it cannot be assumed or presumed that he is guilty, because if he was innocent, he would speak. The law says that he has the right to silence. Number 3, the burden of proof is beyond a reasonable doubt. And frequently in cases of domestic violence, we have a situation called he said, she said. She's got a black eye. The police come. She said, he assaulted me. And he said, no, she fell and hit herself in the bed. The proof beyond reasonable doubt is very important, because the law in situations where there is he said, she said, says this, that if the judge believes the accused the accused walks, obviously. I didn't do it. She fell and hit her eye on the bedpost. Or number two, if the judge is left in a reasonable doubt, not necessarily believing the accused, that doubt must be given to the accused. Number three, even if the accused is disbelieved by the judge still cannot convict until she is satisfied on number four, proof beyond reasonable doubt from the available evidence that the accused committed the assault on the complainant. Proof beyond reasonable doubt. And when you see that that is the case, you will probably understand why the Crown sometimes no charges certain file where there is no substantial likelihood for conviction. And number four, the work we do must be done in a fair and public court. In other words, it's an open court, and there must be an independent and impartial tribunal or judge hearing the case. Now, this public court is seems to be very self-evident in Canada. We frequently turn on the television. We have court scenes being shown in the news or in drama, but that is not a given in other countries. Court cases are done in secret. But this public court has a high price. In other words, for victims of crime, for children to talk about crimes that were committed against them, it makes it very difficult for them. So if I were to point and pick any one of you and ask you to share right now on Zoom your most pleasurable sexual experience, most of you would immediately recoil and find it to be very inappropriate of me to ask that of you, despite the fact that I'm asking you to tell about something beautiful, something good, something pleasurable. Now take a look at this. I now am asking this 16-year-old girl who was raped by her boyfriend. And then what happened after he ripped off your clothes? What did he put his penis on you? You see the difficulty of the victim. You know, many times we look to the court for solutions. We look to the court to solve the problems of domestic violence. Many times it is a very blunt and sometimes very useful tool in curbing domestic violence, but court has very difficult steps and obstacles for victims of crime. By definition, when I ask a victim to come to court to face the accused and tell the judge, repeat what happened, I am in some way re-victimizing her. I am subjecting her to cross-examination. And frequently she is still in a state where she has not recovered from the trauma and she's being asked leading questions, cross-examination questions by the defense, making her feel disbelieved, and with the accused smirking at her not remembering if she got hit 4 times or 7 times, or how come she said 3 times to the police, 4 times to the Crown, and now 6 times to the court. That is the difficulty that the complainant has to go through. Now, this is not a criticism of the defense. The defense has a very crucial and important role to ensure justice is done. But perhaps it is now time for us to re-examine why we permit cross-examination for vulnerable witnesses. If the Crown were to ask leading questions of the witness, there will be immediate objection from the defense because I am putting words in her mouth. If the police were to ask leading questions of a vulnerable witness, which would include a child, there would be proper objection from the Crown and the defense because now you're putting thoughts into the mind of the child and you're no longer getting a pure version. But somehow when it's now time for cross-examination, it is okay to ask cross-examination question of children, of people in trauma. Why is that so? Well, there is a historical reason for that. Historically, it has been held that cross-examination is one of the greatest invention of Western democracy. It is the greatest tool and engine to determine truth. And in fact, that phrase stated by a jurist has been repeatedly affirmed as the right of the accused to confront witnesses. And perhaps it is now time to reconsider that when that pronouncement was made, that it is the best tool to determine truth. We did not have the social sciences at that time to say the impact of cross-examination on children and vulnerable witnesses. We did not know and did not understand or did not even comprehend that children or vulnerable witnesses or those mentally unwell or those under serious trauma will be on the witness box. We really need to do things differently. Will that happen in my lifetime? I don't know, but I fought for it on the date I retired. Now, the role of Crown Counsel is complex. So what I will do is I'll just do it in bullet point. 1 is charge approval, 2, bail, 3, victim connection and support, where the advanced interview that Pam talked about happens. Number 4, victim engagement and preparation. 5, plea resolution. 6, preliminary hearing and a trial. 7, sentencing. 8, appeal. That's a lot. And what I will do is I will animate each part by giving you illustrations to help explain it. So many of the work that the prosecutors do is behind the scene. And because it is behind the scene, people do not see that. But one of the most significant and fundamental work done by the prosecutors of British Columbia is called charge approval. You don't have that in Alberta or Ontario, where police lay charges. In BC, the Crown lays the charges. And I think it is a good thing. Nothing goes to court until the Crown is satisfied that there is a substantial likelihood for conviction. In other words, there's a strong and solid case of substance to present to the court. 2, that it is in the public interest to prosecute the file. So you would look at the prevalence of the case, the seriousness of the injury, the circumstance of the accused. Is he a person dying of cancer in stage 4, coma in a hospital? You know, these are things you look at. But let's focus on domestic violence. In intimate partner violence cases, where the evidentiary test is met, in other words, it's a substantial likelihood for conviction, it is generally in the public interest to proceed with a prosecution. Now, I will tell you that in my 3 decades in the justice system, our government has tried to address the problem in many ways. It used to be, and Jim's one of those old guys there that can confirm to you, if the victim says no charges, don't want one, go away, that's the end of it. We, in the name of respecting their autonomy, say, okay, no charges, thank you, one less file to work on. And then on the other extreme, we had a policy imposed by the government, and the policy was called the zero tolerance policy, where every single case of domestic violence must be dealt with by the police. There must be arrest, and where there is an evidentiary basis, where there must be charges. Those are the 2 extremes, and they're both very unhelpful. What we have now is the middle ground, where the Crown retains the discretion whether to lay charges or not. And this is a very complex case, and let me animate this for you. The girl's 15 years old, really rebellious, truly mouthy, and to the host, I'm getting people trying to enter the room, so I'm admitting them now. Very mouthy. And the father, a very hot-tempered man, single dad. One night, she refused to do the chores, refused to do the dishes. She kept on speaking on the telephone, and back then it was one of those handheld phones that's connected to the wall. She won't get off the phone, and the dad said, get off. And then finally, the father had enough. He grabbed the phone and hang up the telephone, and the daughter said, and this is a true story, lick my clit, Dad. And immediately the father slapped the daughter's face because of the extreme disrespect. And after that, the daughter went to the room, called her friend, notified her friend's mom called the police came. Question, should the father be charged for slapping the daughter for this act of extreme disrespect? Now, I do not have time to do a poll, but some will say, you know what, child abuse is child abuse, he must be charged. And then if I don't charge, then they will say, well, hang on, what's going on here? So there's the intelligent, reasonable people will have different approaches to this. Another example I have is the husband, a truly loving man in his 60s, exemplary business record, because of illness and significant stress, lost it, and took off his cloth baseball cap and flicked the baseball cap at the face of his spouse and scratched the eye of the wife. The wife had a little bit of bleeding in the eye, and he instantly was so sorry because he never intended to cause any injury. He intended to apply force to just get out of the way. Should we charge him and settle him with a criminal code offense, which would impact his life? It's a question that reasonable people may or may not agree on. So as prosecutors, we engage in charge approval. Number 2, bail. The lawyers call it judicial interim release. Once the accused is arrested, we have to decide whether he gets in or out of jail. The stays in jail or gets out of jail. When we can only do so in accordance with laws, Judge Ferris says, we act in accordance to what the criminal code says. 1, is he going to show up in court? 2, do we need to protect the victim? Is there a substantial likelihood that the accused will reoffend or interfere with the administration of justice? 3rd, do we need to maintain the confidence in the administration of justice? In other words, we got a really super strong Crown's case. It's a very brutal assault. There's video evidence of what happened. This guy's going to jail for a long time. Do we have all of these factors that calls for the detention of the accused to maintain confidence in the administration of justice? So let's animate this again. Remember, Bobby took the baseball cap and struck the wife. I would be the first to seek his release after having spoken to the wife and said, you know what? I am so sad that this is where it's at, and he has never done this, and I know he will never do this again. He was in a bad place. I would even agree to a no contact order if I have all of those circumstances. So that requires the Crown to exercise a significant degree of discretion and judgment based on information received. Now let's change the facts a little bit. The accused was on bail for assaulting her 3 weeks ago. Do you see that little fact will now cost me to potentially seek his detention, notwithstanding the minor nature of the assault? Number 3, witness connection, support, and engagement. This is a very important work of the Crown that is behind the scenes and unseen by the public. Let me tell you an example of how I did things wrong. Early in my career, I had this robbery case where the victim had a firearm held at her face. Significant amount of money was stolen. It was a ring of heroin addicts robbing jewelry store, and the total take was over $5 million, to which they just resold this in the downtown east side for 10 cents to the dollar. The witness, the manager of the jewelry store, was the key Crown witness. I needed her cooperation. She would not give it. I went to her store to talk to her nicely, and then she continued to refuse and said, you cannot guarantee my safety. You cannot guarantee the safety of my family. What's in it for me? I'm going to lose a day's pay. And this is what I responded. And every word I said is true. Ma'am, you have a civic duty to testify. 2, if you don't show up, a material warrant may issue for your arrest. All factual evidence, but you will see how completely lacking it is in the trauma-informed approach. We didn't know these words 30 years ago. And what, you know what I got in return? I was told to F off, and she screamed and yelled at me and told me to leave her robbery store. Translate that now to a domestic violence victim. This is the part where we connect with the witness. We explain the court process, what is happening, because when information is given about the unknown, it reduces significantly the stress. And we connect them with victim services if they have not already been connected. We discern their relationship goals in that advanced interview that Pam talked about. For example, what is your expectation and hope for this relationship? And she says, you know what? I've had it, 30 years of abuse. I'm out of here. Do what you can, you know. Or they says, you know what? No, I'm not interested in this. I really see a potential for that. You should have seen him 10 years ago. He is a changed man now, notwithstanding the fact that he gave me 2 black eyes, but he's a changed man. So we discern where they're coming from. And there is really a balance here to be struck between the autonomy of the adult witness, whose autonomy frequently is not truly free because of many, many factors that limit your ability to make a true and voluntary decision. We balance that with the public interest and what needs to be done to protect women from violence. Let me give you an example of what can happen in this meeting. I had a domestic victim from a certain ethnic group, and she gave birth first to a boy, to a girl, and secondly to a girl again. This angered the husband, her sister-in-law, and the mother-in-law, because she has failed to give them a grandson and has done nothing but give them girls. And the assault was brutal, including the use of a rolling pin and knocking her teeth out. She came to my office without her teeth. She did not know that that was not good. That was not okay in Canada. So I read section 265 and 266 of the criminal code to her. And you say, you know something, in Canada, they can't do this to you. And if they do, that's a crime. Really? We need to make allowance for people who may not know what the law is. Another illustration where she did not want to testify because she repeatedly said this: what would the community think? The community will not support what I'm doing. The community will not want him, a prominent businessman, to be in the courts. The community will not agree to this. In fact, the religious outfit will not agree to that. And I said, can you please tell me who is the community? And then she said, well, it's the general community, my family's reputation and our family's reputation in the home country. And I lost it, and I admit, but I said, screw that community. A community that will stand by and let you be assaulted in the name of preserving the reputation of whatever is not a community that you will want to belong to. And thankfully, I had built enough of a relationship to say that in the presence of victim services worker who was of the same culture as she was, who said, yeah, that needed to be said. And from there on, there was a determination that I must proceed without constantly worrying about the community when it is my body that is being beaten up, when it is my children that watches mommy crying to bed. So when we identify and overcome the multiple barriers to cooperation, this will really set the stage for some success in the criminal justice system. Let me give you another example. The spouse was assaulted, the accused was released on bail, and she, on her own initiative, reestablished contact with the accused while the accused was on bail. She was assaulted again, the accused was arrested. He was released because apparently it was the victim that forced the accused into this position. So then she got assaulted again. And this time, the accused said, you go to the cops one more time, I'm going to break your effing neck. So she's now in my office. We're talking bail. And she told me, who are you to tell me how I should run my love life? She was full of anger and resentment at the fact that I'm seeking a no contact order and seeking jail for him. And when you are in that spot, of course, we understand now through the work done by the academics, many of which are in our midst, is that there are many things that inform our personal position. And I tried to say, you know something? You're not a bitch. That's his favorite name for her, bitch. And then say, in fact, you're not even a cunt, because then he would use that to describe her. And to my surprise, and the jaws of the specialized victim unit and the specialized victim services, their jaw dropped. She said, you know what, actually, I've got a baseball cap at home that has the word cunt on it. For some reason, she was proud of it. And where do you go? All of us here are interested in helping people, but there comes a time where we need extra skill to deal with this. So I said, I'll just make up my name, Deanna. You know, I have this vision, I have this goal, and you tell me if you're on side with it. It is really my hope that you are never, ever assaulted again by this man or any other man. Can you buy into that? She paused. And then she said, well, okay, yeah, I can work with that. And then that opened the door. So what it is it requires a lot of wisdom, a lot of understanding, a lot of patience, a lot of suspension of judgment in order to actually reach out and help them. And when they feel engaged, feel consulted, feel valued, this will empower them to get out of that situation. Number 4, we need to prepare a witness for court. When you prepare a witness for court, this is absolutely crucial. Many times that is the only evidence you have. I need to identify what are the barriers to her testifying openly and honestly. Let me give you an illustration that will animate this. I asked the young child, or what do you feel about telling the judge what your uncle did to you? And the child said, no, I don't want to do this, no. And after careful listening and asking non-leading question, can you help me understand your feeling right now? And as she talked, she started to say that when uncle was going to abuse her, she would actually look forward to it, because what uncle did to her, which was oral sex, was pleasurable to her. And she would facilitate it by taking off her pants and just spreading her leg to make it easier for uncle to do what he did. And it dawned on me, she was just racked with guilt that she was responsible for it. It wasn't uncle's fault. Uncle did nothing but give her gifts and surprises, candies and ice cream. And then I always have the benefit of excellent victim services work who say, you know something, victim services, Gina here, you know, she has a vagina like you, and she will tell you that if it is touched nicely, it would feel good. Right, Gina? And it's a very normal thing for your body to feel that way. And then, of course, the child was struggling with the fact that every fiber of her brain is telling her, it's wrong, it's wrong, it's wrong, but the body's saying it's not bad. And after we were able to address and acknowledge that her body felt good, when things happen to it and that she is not at fault, she is the child, she is not the adult, she then was able to testify. In fact, in court, they asked, when he put his tongue on you, can you tell the judge what you felt? And she said, actually, it felt really good. And how powerful is that evidence? And the accused was convicted, because that's the evidence of her describing the sensation her body felt was so compelling, so convincing, the accused was convicted. That can only happen if there's a proper prosecution, patience, working with the witness. We also recognize that in preparing a witness for trial, we have to be careful because we have to disclose everything to the defense. And many times we receive recantations like, well, no, I didn't. I called the police because I was really, really upset and mad at him. It didn't really hit me. I was the one that was trying to hit me, and he hit me, and he was trying to defend himself, and then he hit me. That has to be disclosed to the defense. That will permanently impact her credibility, even if there are future assaults that happen. Because any defense counsel could properly say, hey man, you told the police A last time, did you not? And then you told the Crown that you lied. Is that true? So when you talk to the police, you are willing to lie, correct? Yes. And that is so damaging. So what we need to do is when we approach our witnesses in the advanced interview, we try our best to elicit good evidence and just to be very careful that we make it safe for them to tell the truth without having to cover up for the accused. Now, if there is, of course, lies, true lies made by them, that must be disclosed to defense, and I will be happy to stay that file. In a recent file, before I retired, the accused presented a sworn affidavit saying that she lied in her statement to the police. Now, this was a particularly strong case with every injury corroborating her account to the police. And then he took a cigarette and he burned my armpit. Well, guess what? There's photographs of burns in the armpit. But with that sworn document, under oath, I am putting a perjurer on the stand. And what are the chances of a judge reaching a conclusion safely that this witness, this confirmed perjurer, can be trusted to convict and potentially to jail somebody? I am out of time, and I would still have to talk about the trial. I talked about sentencing, and I am glad that we were able to spend that time to hear from the previous panel. So I will cut my presentation and ask myself, before I started this, I thought to myself that you are giving up your time to be here together with people committed to the same principles, the same cause. What takeaways can you give? What takeaways can I share with you? And I will share with you this. First, that the scourge of domestic or intimate partner violence truly robs women and children of their equality rights. It has no signs of abating. In fact, during the pandemic, there was just clarion calls throughout to say it is out of control. It is out there with little hope, little access for the victims of domestic violence. The harm and damage done to our victims is long-lasting and generational. The courts alone cannot solve the problem because so few of these cases get to court. And same like the sexual assault cases, very few ever get reported, very few get to court, and fewer get convictions. Same principle with the domestic violence case for similar reasons. So we need to really start thinking outside the box. How can we deal with domestic violence outside the court system? Now, you must do everything you can as stakeholders to improve our court system for those in it and who will be in it. But at the same time, to recognize that there are other remedies and to think outside the box, because the mission is urgent, it is critical, and the goal of NEVR is to end violence in relationship. And I hate to be a pessimist, but I am just worrying if we will ever get there, if we continue the same old court route way. There is only so much a court can achieve. And what we need to do is to really work on prevention. We must salvage the next generation and raise a generation of boys who will step in and step up. We imagine this, a generation of grade 5 students all coming out, truly believer that violence is wrong, and that when they will always stand up against bullying, against abuse, against looking down of people. That will make a big difference. Let me give you an example. I told my two boys that you are never to use the word bitch in reference to a woman, no matter what they did or what you think they did. And if you hear somebody call a woman a bitch, I want to invite you to make sure it's safe for you to do so and to stand up and say, you know something, that waitress was not a bitch. She was doing her best. Please do not call her a bitch. If we have a generation of boys that know how to stand up for that, we are in good shape. But to see prevention, strengthening the family unit, improving resources for mental health, to address many drug and alcohol issues that fuel many of the drastic violence committed against women. These things require significant cost, and it is not sexy. And these results will not come in an election cycle. These results will take generations to see, but until we are willing to say, you know what, here's $8 billion. We're going to commit to this, in addition to, of course, what we're doing in court. And then there will be hope. We need to strengthen the family unit. We need to have a collective societal return to moral, social, and values. Don't do unto others what you don't want them to do to you, for example. And in terms of helping those who are offenders, I'm very glad to hear our last speaker talk about the resources offered for them. We really need, and I know there's studies already out there, but more real world lived experience stories from offenders who have turned their lives around and say, teach me, how can we reach people who commit violence against their spouse?
Winston,
Now, yes.
I have a question here. I wonder if we can move to the Q&A. The question is, with family court orders with enforceable by the police written on them, other times we don't. What are your thoughts to have this line written on all family court orders if the same victim has an open file in criminal court?
I would like Pam Batty to, if she's still there, or Judge Ferris to answer that.
I can answer that. It depends what kind of order it is. It depends if it's a family order or if it's a criminal order, for one thing. So the criminal bail and probation orders are always enforceable by the police. And similarly with the protection orders for family, I suspect that the person may be asking a question about parenting time orders being enforceable by the police. And I don't know who asked that question, but perhaps they can let me know if that's what the question is.
Suki, is that what your question is? You're muted, Suki. Can you unmute, please?
Yes, that was my question, Your Honor. And,
it was about parenting time?
If it was parenting time and you already know there's a criminal court matter happening, and then they start proceeding in family court, is there any way of just having it enforceable by the police no matter what? So they're not having to deal with so much through criminal court and then family court on the side, just because there is this retaliation, taking place where now they're going to bother them through family court when they're already dealing with criminal court. I guess there's exceptions made in family court already for enforceable by the police written on certain orders. I was just wondering what your thoughts were on why not have them for those family court orders when a domestic violence person is already in criminal court?
Well, first of all, the Family Law Act is actually drafted in such a way that the protection orders are only enforceable through criminal charges. So I can't make any orders saying that they're enforceable by police because they're enforceable through the police already, through the criminal for breach of a court order. And that's the only enforcement there is on a protection order. On family law parenting time orders, if that's what you're asking me about, I think the case law is I can make if there's no overholding by one parent, I can make a police, not a protection order, I can ask the police to go and get the child and return to the other parent. But that's only once. It's not like, you know, every time someone's 10 minutes late, I'm going to have them phone the RCMP to go and pick up this child, because that's not in the child's best interest either. And that's what I have to look at in a family law matter for parenting time, is what's in the child's best interests. I don't think I have the jurisdiction to order it as a continual ongoing order where the police are constantly transporting a child to and from guardians.
Thank you. Winston, I believe you have some final words you wish to say?
Yes. The work that we do is noble indeed. In fact, I know many of you on the screen, and I'm so grateful that you continue to do the work that I am no longer able to do. What we see in the examples I gave you, examples of truly deep and great evil, and it can depress you when after all these decades of work that you have done, we are still here. We will only succeed if we no longer need to meet together, but we continue to meet because it is elusive what we want to achieve. But what we can do is to certainly light that candle, be that candle in that dark room. And right now, I am standing and sitting beside candles that together will burn bright. And we will tell people who are intent on disrespecting the equality rights of women that we are here to stay. We are that community, we are that army that will stand behind every woman that has been abused and beaten. It is very important as well as to take care of each other and to take care of yourself. This work will drain you. I have been haunted by images of what men have done to women. And so, sadly, these images have stayed with me. I've seen 2 psychologists to help me work with it. I am doing well, but these are the kind, that is our reality. And the last point I wish to make is that I use the word, we need to think outside the box and see what we can do differently. And I will not leave you with these platitudes, but rather give you examples of how it can be done. I'm very pleased that Jim Sesford, when he was then chief of Delta Police, he supported the Courthouse Dog Initiative with Kim Gramlich, who is also with us to advance this program where we have accredited facility dogs that were able to help victims, children of sexual assault, to go to court and testify. I thought, we need to do this. You know, I am in court and I ask for a screen to protect the child, and the defense objects, saying, well, I need to see the witness. The accused is entitled to see the eyes of the victim and confront their story. And I was saying, where is the accommodation for children? Can we continue as a society to permit our children to be abused again in our courtrooms? And I said, no, let's do something different. So I said, we will bring a trained accredited dog to accompany. So I went and presented to the defense bar, and Judge Ferris is here. I should introduce them to the judges to let them know that this is a legitimate program to help children tell their story in court. And of course, I got objections to say that, no, the courtroom is not a Zen room. You are taking away the ability of the defense to rattle the child. But we persisted, and because we did, we were able to make some differences. And here's what happened, and I can share that with you.
Thank you very much, Winston, for that. Highly informed. Oh, there's the dogs.
Okay, I'll just
Hello,
finish
Tabor.
off. So this is an example where we did something different. And now, because of the work done by Delta Police under the leadership of Sesford and Kim Gramlich, I fought for this. And now we have accredited facility dogs helping children testify in court. Did I ever imagine I would do this when I started in prosecution? No, but I was forced to innovate. And I'd like to celebrate one of our speakers. Do you recognize Sheila Early? She is the godmother of forensic nursing in Canada. I recognize that our victims are are well treated by forensic nurses trained to help them, trained to go to court. They are not, understandably, the emergency room doctors are very busy. They resent the waste of their time having to come to court, be cross-examined. But she endorsed this program. I found that it was useful. We supported it, and I fought for it in court. It was challenged as, I object. She's just a nurse. She's not a doctor. To the establishment of a benchmark for forensic health sciences in Canada. This is Amy Falkenberg, but BCIAT is establishing forensic nursing, and they are a gift to sexual assault victims, to domestic violence victims in the way they take care of them. And when you do, and I hesitate to show you this, you will get your recognition in due course here for the contribution and promotion of the advancement of forensic nursing. Now, I say that to say that that reward came at the end of my career. You may not see any gift, any rewards in the midst of your difficult work. It will come for every person that is saved from a violent situation, for every person who have found freedom from violence. We need to celebrate that so that we can continue to do the work that we do. Thank you.
Thank you so much. Are there any further questions for Winston? And if you can't think of a question now, or you can't articulate your question now, please put it in the chat and we will get answers to you over the course of the conference. Whilst you may be thinking about some questions, I just would like to say a huge thank you to everybody who's attended, everybody who's made this possible, for our technical support from AJ Chima, from Balbir moderating in the background, and for all of our speakers. We have one little activity, which is a little quiz. So the acronym NEVR. We will have prizes of 5 President's Choice $25 cards for the first 5 people who can type into the chat what E stands for in NEVR. And whilst people are doing that, I see Jim. Unmute, please, Jim.
Thanks, Jen. Winston, that was an outstanding presentation. Thanks very much. It was very direct. And those are the cold hard facts that the frontline people in Crown work with in dealing with domestic violence. So thanks for telling it like it is. I'd also like to say to you that you took on the good fight relative to the compassion dogs in the courtroom. And that was a huge win. And what it did is set the tone or the precedent for courtrooms right across Canada. And you need to be very proud of that. And I know that our staff in Delta Police Department were absolutely thrilled when you actually were able to make that happen. And so good on you, Winston, and thanks very much. It's an honor to work with you.
Balbir.
I just wanted to thank Winston and all the speakers very much for enlightening us about the court systems and what happens from the time we do get a 911 call, and all the trauma that occurs not only for survivors and the perpetrators, but also the people who are working in the system. And so we've learned that today, and then tomorrow we're going to have challenges that survivors talk about and the research that's being done there. So I just wanted to remind everyone of what day 2 holds. And also that if more people could write the answer for NEVR in the chat box, there's still a few more prizes we could give away.
Well, I've got the first 5 names. So I've got Corinne Limpo, Cher Rampton, Barry Goodwin, Hannah Varto, and Suki Najor. Congratulations. We will be emailing you with those prizes. Balbir, is there anything further before we finish up for today? You're on mute.
Yeah, I was just trying to unmute myself. And the mouse kind of runs. I just want to thank everybody for being patient with me as I'm trying to do the background stuff. I do have tech support with me and AJ, but I wanted to learn. So thank you for putting up with that. Tomorrow, there will be live speakers, so you don't have to worry about me showing videos. And I'll see you all tomorrow.
That's correct. Tomorrow's speakers are Raji Mangat of the West Coast Leaf and Haley Hermack from Rise Women's Legal Centre. And as Balbir said, they are both speaking live. So hopefully we'll be better timekeepers tomorrow. Thank you everybody for being here. Just a reminder that there is a certificate of attendance for this conference, which will be available to anybody who wishes so. And a huge thanks to all of our speakers. That was invigorating.
May I ask, is it the same link that was changed today for tomorrow?
Yes, the link that we had to change today will be used for the rest of the conference.
Wonderful, thank you.
Yeah, thanks. So, see you people. Thank you so much, everybody.
All right.
Ty and Corinne, if you just want to stay on this call for 5 more minutes and we can do our check-in.
Okay, sounds good.
Balbir, take it, can you stay as well?
Yeah, I'll stay. I was just about to end the conference.
I just want to do a check-in with 2 of our students.
Sure.
Jim, are you staying with us or are you leaving the conference? Albir, can we stop recording?
Yes, we can, as soon as I can find the button.
And we need to save the chat before we close this.
Yeah. Let's see if I can find, oh, there we go, stop recording. Okay, there we go, it stopped. And we still have some people with us.
Can you kick them out?
Probably.
As host, I think you can probably do that.
I can.
Ty isn't here, by the way, either.
I've noticed that, Corinne. He possibly couldn't stay beyond 4 o'clock. So
I just texted him, so I don't know if he's going to come on or not.
Oh, well, thank you.
I'm just removing people.
Mm-hmm.
Harsimran's not one of our students, correct?
Correct.
We'll remove Harsimran. There we go. Okay, now there's just 3 of us.
Yes.
But,
Ty's going to come on in a little bit.
Okay.
Okay, so just wait for him to come on.
Who is supposed to be doing the tweeting? Because I didn't get very many.
It's Cecilia.
Cecilia has, if you do a search for @violence never, she was having trouble. She was explaining to me that she was having trouble if she tagged anybody, she had to tag people with images.
She didn't tag, not me. I was creating my own tweets when I had time.
Yes, but I went in to the account Cecilia was tweeting from and retweeted and tagged people.
But you didn't send out the actual tweets, only the first one. The rest are just replying to, and then it doesn't say anything, so we couldn't retweet them.
So right, we need to work on our Twitter policy.
I know, we're not the great, well, I should speak for myself. I'm not the greatest at Twitter. Even though I've had it for over a decade, I only started using it last year.
So we'll just continue to ask Cecilia to do what she can, and then we can.
Yeah, Cecilia should be
retweet.
To do me because she was doing it last time.
And she was also tagging me last time. I don't know what's going on.
Yeah.
Right. Corin, are we expecting Ty?
Yeah, he's waiting to be let in the lobby.
Balbir, can you let Ty in?
Yes, I can. The only thing I have off the Violence Never account, I'm looking at the account, is the announcement from yesterday. I don't have anything new going out of Violence Never that I can see.
Cecilia tweeted about every single presenter, and I've tagged you.
Maybe not from Violence Never.
Oh no, she did. I can see it.
How come I can't see it?
Go to Twitter, go to your little...
I am, that's where I am. I'm in Twitter and I'm looking at the Violence Never.
Yep. There's a whole series of tweets from throughout the day. In fact, I'm just about to retweet one and I'm going to tag you.
Okay, here we go. Yeah, see, I still get to, maybe it's because it's a pinned tweet. How do I unpin you young people? Because it keeps bringing me to that one.
Scroll down.
I think there's like a bunch of 3 dots at the top right-hand corner, and then you can just press it, and I think there's like an unpinned tweet thing. I have no idea.
Oh, I'll ask my daughter later after I get off.
Yeah, that is how you do it.
Is it? Okay.
Yeah. Well,
hello, Ty.
Hello.
So this was really just a thank you both for attending today. And
yeah, that was good.
You enjoyed it? Good.
Yeah, I did.
Obviously, so we were just discussing the fact that Cecilia could not tag us in the tweets, but I think we'll just move forward doing the same. Hopefully that you have both been able to take notes from most of the sessions. We will also have available for Ty when you come to write up the chat, and obviously the recordings.
Yeah.
We're not asking you to really do anything more than to say, a short summary of each presentation, and the 911 things count as all one presentation. Do either of you have any questions or concerns?
Do we have to email you our recorded notes on the Q&A sessions like today, or did you want us to do that at the end of the week, or yeah?
Basically at the end of the week or over the weekend, whichever works.
Okay, sounds good.
Okay, this is not, you've been sitting in a long meeting. You're done for the day.
Yeah, that's true.
Yeah. Balbir, is there anything you would like to ask Corin and Ty?
No, I don't think so. Long as we're capturing the gist of what's going on, and then, yeah. I'm good with that.
And Corin and Ty are both available to facilitate on Friday.
Yes. Good. So we had about 80 attendees throughout the whole day. Roughly. That's not bad considering 106 signed up. It's really good because the police and all these people always go in and out. So I'm quite pleased with the actual number that are staying around. And I was very impressed that the judge and Crown and defense, like these are people who make mega bucks, gave up their time.
Absolutely.
To be with us. And Winston too. I mean, he doesn't have to, he's retired. So I'm just very thankful for everyone for all that, they're helping us do, and hoping to recruit Winston to be a consistent Never member now. He was actually one of the first people that was on board with us.
Yeah, he was really good to listen to.
Yeah, he's very inspirational. I kind of like want to listen to him all the time.
Well, this is recorded, and so the recordings will be available later. Ty, Corin, anything you want to say, or can we just finish this up?
I'm ready to finish.
Someone in the chat was asking, how do we get the certificate that you mentioned earlier?
Oh, we can email them or chat, put in the chat tomorrow. We will email them out.
Sure.
Yeah.
Okay, sounds
we
good.
were going to put a template in the chat that they can just type their own name into.
Okay,
all right. We could do that too. Might be easier.
That was your last suggestion, Balbir.
Was it? Okay.
Yeah.
Oh, I forget what I come up with. It's just too many things to remember.
So,
first thing I will. Actually, no, I'll do it on day 3 to make sure they actually participate.
Yeah. So, well, but I'll make that announcement.
Yeah.
Tomorrow then.
Yeah.
Corn and Ty, wonderful. Thank you very much. Feel free to leave. And Balbir, can we kick it off at 12:30 again?
Yes, we can.
To do a check
Yeah.
run?
Tomorrow will be smoother.
Yeah. Okay.
Day
Lovely,
one's
thank
always a pain.
Thank you.
Thank you.
Okay.
See you tomorrow.
See you tomorrow.
Bye.
Thank you. Bye-bye. I know. I'm glad you were the one on camera, not me. I'm wearing.
Look at me. I'm melting.
Hey, I was so well dressed. I just took my jacket off because I'm melting and I have a fan in front of me.
Yeah, I've got a fan in
Window
beside
open.
you now.
Oh, yeah. No,
Yeah.
it's a lot. But no, I love the information and there were lots of positive things about the information. So that was good.
Yeah. We had 65 stay to after the end.
Yeah, that's really good for a conference, especially.
Absolutely is. Yeah. Okay, I have to go eat.
Me too. I will see you tomorrow. Bye-bye.
Yeah, 12:30.
Oh, now I have to, oh, wait a minute. How do we save the chat?
Oh, you could
let's
just
see.
put your cursor all the way up the whole chat and copy and paste it into a Word document.
I can, but AJ, are you still around? He is. Let me just get him to do it. I don't want to screw it up. I know recordings will get saved as one long recording, I think.
Okay, I'll leave you to do that, Balbir. I need to
Okay, you take care. See you tomorrow.
And you. Bye.
Bye-bye.